Hello and very warm welcome to you all. Myself Monisha, and today in this video I am going to take you through the details regarding the power of Enforcement Directorate under Foreign Exchange Management Act 1999. The Enforcement Directorate, commonly called as ED, is a multidimensional and multidisciplinary body engraved with the duty of enforcing the provisions of two important laws in the country, FEMA 1999 and Prevention of Money Laundering Act PMLA 2002. Both the laws are vested with certain unique functions of ED, which can be enlisted as ED is primarily indulged in the investigation of contraventions under the provisions of FEMA 99. The designated authorities of ED perform the task of adjudication of contravention under FEMA and are also empowered to levy the penalty of up to 3 times of the amount of contravention. ED is also involved in the investigation money laundering offences under the PMLA provisions and can also take action regarding attachment and confiscation of property which has been qualified as the proceeds of the crime, and are also empowered to prosecute the persons involved in the money laundering offences. So let's discuss in detail about the ED's investigation in the matters of FEMA. Section 37 of FEMA 1999 has empowered the Director and Assistant Director of ED with the powers of investigation occurring out of contraventions under various provisions of the aforesaid Act. These officers of ED are vested with the same investigatory powers as it is assigned to the officers under the Income Tax Act 1961. Therefore, they have the power to issue summons, conduct search and seizure, etc. Also, the Director and the Assistant Director have same powers as vested under Code of Civil Procedure 1908 in the instant of filing a suit in the following circumstances like inspection and discovery, calling for appearance, including any person of a banking company, and examining them on oath, directing for the production of books of accounts or other such documents, issue of commissions. ED's power to summon under FEMA. In the judicial dictionary, the word summons is defined as to mean a call of authority to appear before the judicial officer. When the summon is issued by the Director or Assistant Director of the ED to a person under Section 37, subsection 3 of FEMA, the summoned person cannot challenge the issuance of such a summons by the ED in the court by the medium of a writ. A case under the Madras High Court will clearly illustrate the meaning. In this case, the petitioner in question was seeking for a writ of prohibition against the order of ED for having issued the summons by the exercise of the powers bestowed upon them under Section 37 of FEMA read with Section 131 of Income Tax Act. Regarding the power of summon by the ED, it has also been held in plenty of judgments that a person against whom summons have been issued, such person shall not be accompanied by any advocate while appearing before the ED, and also the recording of his statement in presence of advocate cannot be allowed. So what are the consequences of non-appearing to the summons issued? In case where a summon has been issued regarding an investigation under Section 37 of FEMA and the accused person defaults of his appearance on the date mentioned in the summon so issued, the ED shall take action against such defaulter under Section 13 of FEMA. The procedure starts from the point of filing of a complaint under Section 16, subsection 3 of FEMA by the Assistant Director, ED, before the adjudicating authority of such investigation. The complaint would depict that the appellant was under investigation by the Directorate for contraventions of the provisions of FEMA, and which were punishable under Section 13, and in connection with the said investigation, summons have been issued requiring the presence of the said person before the said Assistant Director for providing the evidences and for producing of the documents as mentioned in the summons. On failure to comply with the provisions of summons without any valid reason would amount to non-compliance under the legal procedures. Therefore, failure to appear before before the authority issuing the summon would lead to imposition of penalty under Section 13 of FEMA for contravening with the provisions of Section 37 of FEMA read along with Section 131 subsection 1 and 272A subsection 1 of the Income Tax Act 1961. This will lead to the issue of a show cause notice to the person failing to appear before the ED by the adjudicating authority. Prosecution during the adjudication proceedings. After the central government has sufficient reasons to believe that certain foreign exchanges, foreign security or any immovable property located outside India and has been suspected to be held in contravention of the FEMA provisions, then after recording of the reasons in writing, the government shall by an order seize the value equivalent of such foreign exchange, security or property situated within India. This falls under Section 37A of FEMA. During the proceedings of the adjudication of the above mentioned exchange, security, property, the adjudicating authority is empowered to recommend initiation of prosecution in respect of same. The ED is entitled to file a criminal complaint against the guilty person under Section 13(1)(b) of FEMA, after recording the reasons of satisfaction to proceed with the prosecution. The court shall cognizance of such offence in writing by complaint by ED. In case any person is found guilty of having acquired such exchange, security or property in contraventions of the FEMA provisions and in excess of the threshold as prescribed by the government, in such matters, such person shall be punished with imprisonment for a term which may extend to 5 years and fine as well as penalty which may be imposed up to 3 times of the sum involved in such contravention and confiscation of the value equivalent of the foreign exchange, foreign security or immovable property situated in India as falling under Section 13(1)(c) of FEMA. Now let's discuss about the penalties. In case of any contravention of any provisions of FEMA or any rule or regulation thereunder, it would entail penalty up to 3 times of the sum involved in such contravention where such amount can be quantified or up to 2 lakh rupees where the amount cannot be quantified. And in case of continuing contravention, further penalty extending to 5,000 rupees for every day after the first day during which the contravention continues shall be levied. This is explained under Section 13 of FEMA. In case of failure of the person to make the full payment of a penalty imposed within the given time period of 90 days, in such a condition, the designated officer of ED is duly authorized to recover the amount of such arrears of penalty. Such designated officer of ED shall exercise all powers which are conferred on the income tax authorities in respect of recovery of tax under Income Tax Act. Coming to compounding of offences, compounding of offence under FEMA is a procedure wherein the guilty person is allowed to make the monetary payment for committing contraventions under Section 13. Hence, the contravention under the provisions of FEMA are compoundable and civil in nature. For compounding of any offence under FEMA, an application shall be filed to Reserve Bank of India. However, it is to be noted that where any person deals or transfers any foreign exchange or foreign security to any person who is not an authorized person by the way of hawala transactions and thereby is found guilty of such offence, compounding of such an offence will be done only by the ED under compounding of contraventions under FEMA 1999. However, the provision of compounding of offence will not be available in the cases such as where the amount involved is not quantifiable and where the contravention committed by such convicted person has been done within a period of 3 years from the date of a similar contravention committed by him earlier and which has been compounded. It is important to understand that where a complaint of criminal nature had been filed by the ED against the accused, then compounding of contravention is explicitly allowed in such cases also. The only condition in this case would be that the order of the compounding is to be brought into the notice of the adjudicating authority, and on receipt of such notice, the person in respect of whom the contravention is so compounded shall be discharged. That's all for this video. For any other concerns or questions on this topic, kindly email us at info@enterslice.com or call on the numbers mentioned over the screen. Do like, share and subscribe. Thank you.